your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. It is Friday, finally. But there's no rest for people like us. You know, I have to do whatever I can to keep this channel going. I want to thank all the new subscribers to this channel. Okay. Thank you for your support. Thank you for your subscription. Thank you for being part of my family. Everybody is welcome here as long as you behave yourselves. That's all I ask. Behave yourself. If you can't do that, then you'll be banned. And next time when I ban people, it's going to be permanent. There's not going to be any more taking names off the list. So think about your actions before you say it in chat. Okay, today is Judge Aaron Gauthier in the 53rd. I think he's in Sheboygan, Michigan. Say that 10 times fast. Here we go.
Your appearances, please.
Mr. Goodrich, Wayne County Prosecutor.
Good afternoon, Mayor. Please, Honorable Court. Kareem Johnson, on behalf of Mr. Powell, stands to my immediate right.
All right, and this is sentencing on a charge of child sexually abusive activity, 7-year felony. Guidelines were scored at 0 to 9 months. And Mr. Johnson, have you had a chance to review the pre-sentence report and recommendations with your client?
Yes, Your Honor, I have.
Do you have any additions or corrections to the report?
Yes, Your Honor.
Go ahead.
You know, it is going to be the same basis for this OB 4
Oh, I'm sorry. First, I was just asking, do you have any additions, corrections to the factual information of the report?
No, Your Honor.
Okay, Ms. Goodrich, any from the people?
No, Your Honor.
Okay, so go ahead with the scoring challenge, Mr. Johnson.
It's going to be the same legal basis for OB4, OB10. So for both, it is the defense opinion that for both cases, it relies upon evidence from the complaining witness. Here, the complaining witness is unknown and has never been interviewed. So, and it's the court opinion that, well, excuse me, not the courts. It's the defense opinion that under People v. Lockett, 25 Mission Act 165, 2012, and also People v. Hicks, 2003 case, 259 Mission Act 518, a sentencing court may not simply assume that someone in the victim's position will suffer psychological harm. And that is from a case in which the co-defendant was convicted of criminal sexual conduct with minor sisters who voluntarily engaged in behavior. And People v. Lockett was a psychological injury from a forcible purse snatching case. So, but we think the reasoning here is the same, that without actually ever talking to or interviewing the individuals on these videos, the court can only assume that someone in the victim's position will suffer from psychological injury, and courts of higher jurisdiction said the courts can't do that.
Okay, and that's the same basis for the challenge to both OB4 and OB10?
Yes, although the cases are referencing offense variable 4, I believe the same applies to offense variable 10. You would have to have at least preponderance of the evidence on the record to score OB10. And again, with the victims being unknown and no evidence that they were ever talked to or interviewed by police, one, you couldn't attribute any exploitation to Mr. Powell. I believe the exploitation would be to the individuals who produced the illegal material. But even if somehow the OB10 would encompass someone further down the line like Mr. Powell, there's still not that preponderance of the evidence on the record to substantiate scoring of that factor.
Thank you. Ms. Goodrich, People's response?
Your Honor, as to OB4, I would agree that we don't have any evidence of the psychological injury to the victim, since oftentimes in these cases, the victims are unidentified. But I think as to OB10, based on the description of the nature of the offense of these being child pornography videos where the victim was under 8 years old, that OB10, 10 points were properly scored due to youth or agedness. I think that Mr. Johnson's argument may apply if 15 points were scored, but I think it does apply to 10 based on the description of the offense.
Okay, it's an interesting question when this is when we've got cases that involve child pornography and we don't know the names or identities of the victim of the items that were possessed or shared. They were real victims. We just don't know who they are. The Court of Appeals has answered both these questions for us. In OB4, just recently, People v. Charbonneau, November 15th of 2024, docket number 364596. The Court of Appeals held that OB4 may not be scored for serious psychological injury for victims depicted in child sexually abusive material, absent specific evidence of injury to a specific victim. Therefore, I would sustain the defense challenge to OB4 and change that scoring from 10 points to 0 points. The Court of Appeals has also answered the question as regard to OB10, exploitation of a vulnerable victim. In People v. Needham, 299 Mishap 251 in 2013, the Court of Appeals held that OB10 can and should be scored for exploitation of a vulnerable victim, even where the defendant had no direct contact with the victims displayed in the CSAM images. The reasoning was that even the participation in the flow of commerce with those continues to exploit the victim, and we don't need to know the identity of the victim to know that they were exploited. So OB10 under People v. Needham is properly scored at 10 points. It does reduce the total OB from 20 points to 10 points. And this is on the D grid.
Next time you see this plant in your backyard, don't cut it down, because this is the best natural paint.
And so that 20 points to 10 points, it remains at OB level 2. So it doesn't change. The guidelines range remains 0 to 9. Okay, do the people have any scoring challenges?
No, Your Honor.
Mr. Johnson, go ahead with the allocution, please.
You know, my client is 27 years old. This is his first contact, to my knowledge, with the criminal justice system. So PRBs are all properly scored at 0. We've already, addressed this offense variables. Comes back as an intermediate sanction. Under that statute, the court has a plethora of sentencing options and alternatives to incarceration. I think most importantly, for my client, he needs to address the most biggest issue he needs to address is porn addiction, and he's taking steps to address that. I'd ask the court. We think, except for the 90 days, the recommendation about probation is fair. We'd ask the court to consider house arrest, community service, and list of sanctions under the immediate sanction statute in lieu of, as opposed to jail. I don't think there's any reason for my client to have upfront jail in this case. Believe that, and the court hit, I think, the nail on the head when we talked about the Chamber of Commerce and the Court of Appeals' analysis of OB10. I think oftentimes the people I talk to that are similar situations to Mr. Powell, they fail to see or understand how just being in the chain of commerce, affects this situation. And because they create a demand, or there is a demand for this crime continues to occur. My client is sorry. He had already taken steps to address counseling before he even been arrested and charged in this issue. His mental health history is laid out in the PSI. And as we ask the court to sentence my client to probation, court deems that house arrest is necessary. My client would not object to that. And he would want to heal himself and put this matter behind him, Your Honor.
Thank you. Mr. Powell, it's not required for you to make a statement today, but it is allowed. Is there anything you want to say or no?
No, I do want to try to, as you said, seek counseling for this. Try to become better, try to move past this.
You want to seek counseling for this? Have you sought counseling
Yes,
up
I
to
have.
today?
I actually seen my therapist. Her name is Heather Cornett, Second Chance Counseling.
Oh.
I am taking my antipsychotics and antidepressants. I am trying to seek further help with my mental issues. And I hope that maybe I can try to better myself.
Okay, thank you, sir. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant is 27 years old with no prior criminal history. He is unemployed with a high school diploma. The sentencing guidelines are 0 to 9. Given the goals of sentencing, I believe that the 5 years probation does address the rehabilitation portion. But as to punishment and deterrence, I believe that jail time is appropriate, given that, as was stated, even though he didn't specifically exploit these kids, he did by participating in this industry, and the child pornography industry would not exist if there weren't people viewing it. And so deterrence is important in these cases, as well as punishing this behavior. I would recommend 6 months jail. Thank you.
Thank you. Mr. Powell, if you please stand for the court sentence. Well, Mr. Powell, it looks like sex offender registration was completed by the Department of Corrections as required. I think based on this conviction, the court will be sending paperwork to the Department of Health and Human Services to place you on the central registry as required by statute. You're 27 years of age. You have no prior criminal convictions. You do have some mental health challenges and diagnoses. You've had some terrible things happen to you when you were a child. I read about those in the pre-sentence report and don't need to go over those here now, but I did review all those. And you have a 4-year-old daughter. In this case, you're charged with child sexual abusive activity, distributing or promoting for not only viewing two absolutely horrific videos of child sexual abuse, but sending them to somebody else. So you saw this and thought this was somehow enjoyable enough to you that you were going to send to somebody else for their perverse enjoyment. We covered this with the scoring challenges. You're looking at a video on a screen. It's a real child, like your daughter. It's a real person. And, I've defended people involved in this. I've prosecuted people involved in this. I've adjudicated people involved in this. They're all horrifying cases. And the images and the videos are all horrifying. And the description of these caught my breath. One of the videos you shared was an 8-year-old child being violated by an adult male from behind, violated by a teenage boy from the front, with her eyes duct taped. You think about what that girl was going through, and maybe still is today if she's alive somewhere. And somehow you think that's something to send to somebody else. It's hard for me to put myself in your shoes and I try to, when I sentence people, imagine, I've read about some of the things that happen in your life and try to have sympathy and empathy for where you are. You've made that pretty difficult. I cannot imagine seeing a child who's probably been kidnapped and is being tortured and quite likely is dead today, duct tape over her eyes. And you think that's a fun time for you to send to somebody else. That's sickening, horrifying. What do we do with you? What are we supposed to do with you? You have a 4-year-old girl? How safe is she from you? That's what I worry about.
No offense, but if you're paying over $30 a month for car insurance, you're getting ripped off.
Given the charge, the probationary term is mandatory 5 years. We're going to place you on probation for 5 years. That's subject to the terms and conditions listed on pages 2 and 3. Those include participating in sex abuse prevention programming or treatment, complying with the Sex Offenders Registration Act, strict limits on any computer usage, getting a job, paying $130 crime victims assessment, $350 in court costs, $68 in state costs, DNA testing, $60, monthly supervision fee. I'm just highlighting some of the things. All the things in there are going to be in the probation. There's another one. You must not have verbal, written, electronic, or physical contact with any individual 17 or under, or attempt to do so either directly or through another person, unless you are with an adult responsible for that individual and have first obtained written permission from the field agent. That includes your daughter. You don't get to be around her unsupervised. And I don't yet, you say you're in counseling, I don't yet have any sex offender risk assessment. So here's what I'm going to do. I'm going to amend that probationary order as follows. For that condition, you may not have verbal, written, electronic, or physical contact with any individual age 17 or under, or attempt to do so either directly or through another person, period. That means you are done seeing your daughter. You're done talking to her, no contact with her. Now you can always petition for me to amend the terms of probation, which I will do if it's reasonable. Before I let you see that little girl, I want to see a sex offender risk assessment and treatment progress notes so that I can sleep at night thinking that maybe she's safe with you and not going to be duct taped over her eyes by you. This case, although it is intermediate sanction, does call for jail. I'm going to give you top end of the guidelines. I think that's proportionate, 9 months jail forthwith, credit 1 day served. You can file an appeal if you wish by filing an application to the Court of Appeals. If you want a lawyer, you got to ask within 6 months. We're going to hand you a piece of paper explaining that appeal process. Ask you to initial 1 copy for us. The other one is for you to fill out if you want to take an appeal. Within 24 hours of your release from the jail, you have to contact your supervising agent. Oh yeah, credit for 1 day served. 2 days served. Credit for 2 days. Yeah. Okay. And then I know we're behind, but now it's 4 o'clock. We're going to take a brief recess and reconvene at. All right. So we're back on the record, and I discussed with counsel a couple aspects of what I anticipate to be the scoring challenges, and also a concern I had about credit on the plea agreement. And also, the prosecutor advised me that the minor victim is present in the courtroom and does want to make a statement. And after consulting with her mother, with the victim rights person in the prosecutor's office, and with counselors or helpers from the Women's Resource Center, does wish to make that statement in open court with the matter being live streamed. Even given her age, it's important to her and her family that the community know about this offense. Is that correct, Ms. Goodrich?
That is correct.
All right. Mr. Johnson, scoring challenges? Go ahead.
Your Honor, as to the 25-6978 FC case, as indicated, we'd object to OV 11, reasons discussed off the record, OV 13.
In the other file.
In the other file, we'd object to OV 13 being scored.
So as I understand, Ms. Goodrich, then, and we did discuss this at the bench, but for the record then, in the 6978, the CSC third, OV 11 was scored at 50 points for other sexual penetrations. However, those would have to be other sexual penetrations arising out of the same transaction of the sentencing offense. And I didn't see sufficient evidence of that. So I would, it wouldn't count the whole course of conduct. It'd have to be arising out of that event itself. There were multiple penetrations at the same event, for example. So I'm inclined to agree with the defense objection on OB 11. Anything contrary you want to place on the record, Ms. Goodrich?
No, thank you.
Okay, so in 6978, OB 11 will be scored at 0 points rather than 50. The defense also objects in file 7035 to the scoring of OB 13 at 25 points. that's properly scored in the 6978 as the offense, the CSC third being a part of a pattern of offenses involving criminal sexual penetrations or crimes against a person. But in the 7035, it being a conspiracy to obstruct justice, that's a public safety or public order crime. So therefore, it itself would have to be part of the pattern under the case law. And so I'm inclined to agree that OB 13 should not be scored at 25 points. Do you have any position with regard to that, Ms. Goodrich?
No, Your Honor, no objection.
Should it be scored at any points at all, or?
Your Honor, it's our position for the 257035 FH, it should not be scored.
Okay. Oh, that's correct. Okay, I was confusing it with OB 12 about other crimes of any kind. Okay. So in file 7035, OB 13 will be scored at 0 points rather than 25 points. I'd sustain both those defense objections. Any other scoring challenges from the defense?
No, Your Honor.
Ms. Goodrich, any scoring challenges from the people?
Your Honor, in both files of PRV 7, there was more than one felony pled to. So I'd ask that be changed to reflect that.
Okay, so Mr. Johnson, any defense response to an objection to scoring of prior record variable 7 being underscored?
Your Honor, as to 256978, my client did plead to more than one count, so I believe it should be, that one should be 20 points for the second count on that offense and a subsequent conviction for the other case. As to, I'm sorry, I'm looking for the case number.
7035, the obstruction.
At 7035, the obstruction, it was only one conviction, and there was no other conviction after that, so I think that one should remain at 0.
Okay, in both files, I'm going to score prior record variable 7 at 20 points for concurrent or subsequent convictions. This defendant pled to 3 felonies across 2 files total, but 3 felonies total. So when we're scoring the CSE third, there are 2 concurrent felonies. 1, the CSE 2, and number 2, the conspiracy to obstruct justice. When we're scoring the conspiracy to obstruct justice in file 7035, we again have 2 concurrent felony convictions. First, the CSE third degree. Second, the CSE second. So in both files, PRV 7 will be scored at 20 points. Ms. Goodrich, any other scoring challenges?
Your Honor, in the obstruction file 7035, I would ask that OB 14 be scored for 10 points for the defendant being the leader in that situation.
Mr. Johnson, defendant's response.
Your Honor, and of course the burden of proof is about preponderance of the evidence here. The court has to determine what is a leader. My client was in jail. He had no ability to write the letter, deliver the letter, participate in any of that. Now, because he may have wanted the crime to occur, well, that makes him an aider and abetter or a co-conspirator. Even if I suggest to someone we should rob the local bank, it may be my suggestion. I may be the one that puts that out there. But if somebody else does the planning, somebody else gets the car, somebody else gets the weapons, the mask, those things, then that person, or whether charged or not, has encompassed the role of a leader. Based on the facts here, although the crime may have been for the benefit of my client, and even if the court finds that my client may have been the one that wanted the crime committed, when looking at the facts of what was done, what had to be done to attempt to commit this crime, my client could not have been the leader because he was prohibited from doing any of the planning. He had no access to the computer that was at the job and forging this letter. So we do not believe that there are sufficient facts to suggest that he was the leader, although he was the beneficiary, we would have been the beneficiary of the alleged crime.
Okay, in this case, the conspiracy to obstruct justice charge is based on facts that while the defendant was in jail charged with the criminal sexual conduct, he asked another person to fabricate a letter from I think the mother of the complaining witness to present to the prosecuting attorney, which purported to say that she had pressured the victim into making the statements, and so it was offered as exculpatory evidence, and it was fabricated. And so he's been charged and convicted for conspiring to obstruct justice by doing that. I think on a preponderance of the evidence, that's a little bit different than two people talking on the outside, like, gee, should we rob a bank or not? And one of them goes and does it. The one who suggests it is not necessarily a leader. I don't disagree with that. But in this case, somebody who's charged with a crime, who then asks somebody on their behalf, I want you to go fabricate this evidence for me, and they do so. I think the defendant who's charged with the crime and is instigating the fabrication of evidence is in fact a leader in a multi-offender situation. So I would find on a preponderance that Mr. Truman was a leader in that situation. So OB 14 in file 7035 would be scored at 10 points. Any further objection to scoring for the people?
No, Your Honor.
So now we got to do more math. In file 6978, I've added 20 points to PRV 7, which brings the PRV level from 25 to 45 on grid B, which still is prior record variable D, or prior record variable level D. And offense variable, I've scored OB 11 at 0 points. That's reduced the total OB from 95 points to 45 points, which reduces the level from 6 to 4. So the guidelines range would no longer be 84 months to 210 months, but would instead be 72 months to 180 months with the habitual third taken into account. Is that math correct, Ms. Goodrich?
Yes.
Mr. Johnson?
Yes, Your Honor.
Okay, and in 7035, again, I've added, this is on Class E grid. I've added 20 points to PRV 7. That increases the total PRV from 35 to 55, which changes it from prior record variable level D to level E. On the offense variables, I've scored OB 13 at 0 points rather than 25, but I've added 10 points under OB 10. So I think that means total OV would be 20 points, 10 for OB 14 and 10 for OB 19. That means that the level is from 4 to level 2. Is that right? And that would reduce the range. We're at E2. That would be with the habitual third. Now, instead of 12 to 36 months, it would be 10 to 34 months. Is that math correct, Ms. Goodrich?
Yes.
Mr.
Yes, sir.
Johnson? Oh. All right, so now we have our advisory range. Mr. Johnson, anything you want to say on behalf of your client?
Your Honor, starting with 25, 70, 35. The court has already given, as part of the guideline objective recitation, what had happened. My client should not have engaged in that. One of the things that is important to everybody involved in the judicial process is that the process, is fair, and there are no outside influences on the evidence from one side or the other. And I know from the government standpoint, that is the chief evil of falsifying or trying to manufacture evidence of guilt. And the court, in fairness, should look at it the same when the defendant does do it. But I would like to state for the court that the obstruction of justice is the sentencing offense, and he gets an aggravated factor under OB 19, 10 points for interference with administration of justice. And I fully concede that at this point, courts of higher jurisdiction have not agreed with the defense positions that, you're really giving somebody an aggravating factor for what is essentially a sentence of defense. When you look at the totality of circumstances, we'd ask the court to follow the recommendation, and on that matter, sentence my client to fines and costs. As to 256978F3. I do not believe, after getting to know my client, that he is the person that he appears to be on the screen. And I say that knowing full well that we are here now for the second time in which he will be sentenced on a sex offense. And I say that understanding that, he has pled guilty to violating the trust of someone that should have been able to trust in him for protection. When my client is embarrassed, he is hurt for the hurt that he has caused. He has, accepted responsibility. He's, waived his exam. He's pled guilty and accepted responsibility for these offenses. He was blasted all over social media for this offense. He's going to be on the sex offenders list. And these type of cases, and as a product of Catholic school, all through the college, and when I talk to people and they talk about, or I talk with them about Catholicism and criminal defense, it really focuses on a principle that I believe, that nobody's sin is greater or lesser than anyone else's. We've all sinned. We've all fallen short, in my opinion. Now, the law does not take an opinion. We have Class A felonies, Class B felonies, Class C felonies, Class D felonies. I understand.
I'm a lapsed Catholic, but I was taught about venial and mortal sins, so I'm not sure that canon law agrees with you too. But we're not going to get into that, but adjudicating that question today. Go ahead and continue.
Thank you, Your Honor. My client, I do believe, is redeemable. I do believe that he has started in that first step of conviction and repentance and responsibility, acknowledgement of what he has done. And he knows that he can never make right what he has done. But he is here. He is ready to accept his sentence. We ask the court for a fair sentence. And based upon the guidelines, my client's previous record, we would still ask the court for what it is that we were initially going to ask. We know the minimum has now been lowered based on the changes in the guidelines, but it was never our plan to come here today and ask the court for the minimum sentence. We still ask this court for a sentence of 90 months for the capital case, which I believe is fair, looking at the account of my client with this not being his first criminal conviction, not being his first sex offense, but take into account that he did step up and take responsibility for the harm he's caused, knowing the understanding that it's not going to make it any better. The fact that he did that, he should have done it in the first place. But we ask the court for a sentence of 90 months.
All right, thank you. Mr. Truman, you don't have to make a statement today, but it is allowed. Is there anything you want to say today, sir? No, sir. Thank you. And continue a live stream of the proceeding going forward. All right, so it says Paula's iPhone. Paula, we didn't want to put your daughter's image and statement on YouTube. She did just make a statement in open court. The prosecutor tells me that if she did so, that you possibly did not want to make a statement. Did you wish to make an impact statement at this time or no?
Oh, we were hoping that both of us could, but they weren't sure how that was going to work today. So
that's fine. If you want to make a statement, go ahead.
absolutely. All right. So I'm here before you today to express the profound impact that this situation has had on my family. And the actions of Elmer have not only inflicted fear and trauma on my daughter, but they have also disrupted the very fabric of our family. My daughter endured suffering that no one, especially a child, should ever have to face. Witnessing her pain has been unbearable as a parent, and it breaks my heart to see the confusion and fear in my child's eyes. This has fundamentally changed how my children view the world. They now carry the weight of this trauma and lingering fears. Elmer's actions, having his wife writing a letter pretending to be me and trying to make me look like a monster to my children, is just inexcusable. I feel as though a dark cloud has been looming over our family, making it difficult to foster a sense of safety and trust. The trust we once had as a family has been shattered, and rebuilding it is going to take some time and a lot of support. The damage done is immeasurable. My daughter has lost precious moments of her childhood, moments that she will never get back. We're asking the court to impose the maximum sentence allowable, not only because Elmer deserves to be held accountable for his actions, but also to signify the pain that he has inflicted on our family. And that is recognized and taken seriously. We ask that he serves consecutively and the maximum penalty. I hope that through this process that my family can heal and create a future where my children can feel safe. So I thank you for taking the time to consider, our statements today with the impact that it's had on us.
Thank you, ma'am. Okay, and before I take the prosecutor's recommendation, as we're hearing more about this letter, it does cause me to revisit one scoring question. On the CSC case, 6978, OV19 was scored at 0 points. However, OV19 is not subject to the McGraw limitation of scoring facts only for the sentencing offense, but for conduct afterwards. And afterwards, the defendant is conspiring to obstruct justice by fabricating evidence to avoid accountability. I think that definitely calls for a scoring of 10 points for OV19. I'd give both sides an opportunity to be heard on that question. Ms. Goodrich, people's position.
I would concur with the court, Your Honor.
Mr. Johnson, defense position.
No objection.
Okay, OV19 to be scored at 10 points. That brings the OV to 55, OB level to 5. So now instead of my revised scoring at 72 to 180 months with the habitual third, we're in the D5 bracket. So that would bring the scoring to 78 to 195 months. Mr. Johnson, I'm sure that doesn't change your recommended 90-month sentence, but because we've changed the range, I'll reopen the allocution for you if you wish.
Well, Your Honor, again, my client, we understand the court, the minimum. It was never our intention to ask for that. We still ask the court for the 90. Sure.
Okay, thank you. All right, Ms. Goodrich, recommendations from the people.
Thank you, Your Honor. The defendant is 52 years old with 3 prior felonies and 8 prior misdemeanors. He's unemployed with a high school diploma. I would ask the court to consider to exceed guidelines here. I think that there's reasons to, given his criminal history. In 1997, he had a felonious assault, but in 2002, he had a prior CSC4. The PSI reflects that the victim in that case was 5 years old. And then in 2019, he was charged with a CSC4. It was pled down to an aggravated assault. Mr. Truman did receive the benefit of the plea bargain here today. I think that given his criminal history against children, combined with the statements from the mom and the minor child, give reason to exceed the guidelines. Thank you.
Thank you. Mr. Truman, if you please stand for the court sentence. In a first sentence in file 7035, the conspiracy to obstruct justice, there's crime victims assessment of $130, $68 in state costs. There's advisory guidelines scored at 10 to 34 months. It's been my position that the statute requires that to be mandatory consecutive sentencing because it was committed while in the jail. I have a plea agreement for credit for time served and no additional time. Based on my understanding of the statute, I don't feel that I can give him credit for that time. He stands convicted of that offense. To comport with the terms of the plea agreement, I will find reasonable grounds for a downward departure in that. The reason for that is to effectuate the terms of a plea agreement. And in that case, I will sentence Mr. Truman to fines and costs, as I've stated. That's the 7035. Then in 6978, we've got Mr. Truman at 52 years of age with 3 prior felonies and 8 prior misdemeanors, charged with several counts of criminal sexual conduct in the first degree that would have carried a mandatory minimum 25 years in prison. He's received the benefit of a plea bargain for the what amounted to a downward departure for the conspiracy to obstruct justice, and also the reduction from a 25-year mandatory minimum to a 30-year absolute maximum from the CSC third habitual third. That's a significant benefit. And the only fact that changed from the factual basis supporting this no contest plea, the only fact that would make it a first rather than a third is just the age of the victim, which is not factually contested. So really, Mr. Truman is receiving quite a benefit from that, which I think is proper for the court to take into account because it doesn't require consideration of any contested fact. It's just the age of the victim. So then we have an advisory guidelines range at 78 to 195 months after several challenges back and forth. That's an advisory range. And if the court's not going to follow that range, I have to state reasons for doing so and the extent of the departure. Here, I believe that there are grounds for an upward departure from those guidelines range. And that is the fact that, number one, as I've stated, Mr. Truman is avoiding a mandatory minimum 25 years on the CSC ones and mandatory or certainly discretionary, I would have done consecutive sentencing for trying to tamper with evidence while he's in the jail on those charges. Secondly, and even more compelling, this is not the first time that Elmer Truman is standing in front of a judge to be sentenced for sexually abusing a child. It is not the first time that he's convicted of sexually abusing a child. He's been 3 times charged with it. 1 time reduced to a non-sexual assault. He's been twice convicted now of sexually abusing a child. I repeat that because if we were to ask ourselves or ask the community or ask anybody in the criminal justice system, which people coming to court to be sentenced on a criminal sexual conduct 3rd degree should receive the absolute maximum that you can give them, I'm pretty sure the answer would be, have they done it before? And here the answer is yes. I believe that calls for the absolute maximum sentence allowed by law, which I believe is certainly proportionate to the circumstances of this offense and this offender. That means that I'm limited to 2/3 of the maximum. The maximum under my discretion of an habitual third statute is 30 years. So Mr. Truman, I'm exceeding the guidelines and giving you the absolute, what's called Tanner max, and sentencing you to prison for 20 years to 30 years. You'll receive credit in that file for 275 days served. There's state cost of $136, crime victims assessment of $130, I'm also assessing $350 in court costs. And if and when you are paroled on the CSC 2, that would, because the victim is under 13 and you're 17 years of age or older, that would subject you to lifetime electronic monitoring upon parole. I'm going to assess that as part of the sentence of this court as well. That's the sentence of the court.
Oops, something happened. I might have to do this live stream over again. It says none. StreamYard just freaked out on me all of a sudden. That's not right. Oh, don't tell me this is a dud. Nope, right there.
For the County of Sheboygan, we are providing public access both in the courtroom and also online. We have a probation violation arraignment in People of the State of Michigan versus Kayleen Good, formerly known as Kayleen Zarzini, file 23-6704FH. Counsel, please state your appearances for the record, beginning with people.
Melissa Goodrich, Sheboygan County Prosecutor. Eric Villanueva on behalf of the defendant.
All right, good morning. And have you had a chance to review the violation allegations with Ms. Good?
I have, Your Honor. I had an opportunity to go over them with her.
Okay.
I explained them to her. She indicated to me she understood them.
Okay. All right, Ms. Good, it's alleged that you are in violation of your probation in 7 respects. First, that on or about August 7th, you failed to be drug tested. Second, that on or about August 7th, you failed to attend a counseling appointment. Third, that on or about August 8th, you failed to report to your probation agent or case manager. Fourth, that on or about August 12th, you failed to attend a counseling appointment. Fifth, that on or about August 12th, you failed to report to your probation agent or case manager. Sixth, that on or about August 13th, you failed to appear for recovery court. And seventh, that you failed to abide by the terms and conditions of the recovery court program. by failing to complete required community service hours for the first full week of August 2025, and by failing to successfully complete the recovery court program. You have a right to have a hearing on those allegations where they would need to be proven by a preponderance of the evidence. You have the right to the assistance of a lawyer at any such hearing. And if you request and can't afford an attorney, to the appointment of an attorney at public expense, you have the right to present evidence in your own defense at the hearing and to question any of the witnesses presented against you. These are all technical violations. However, the number of them and the number of prior violations means that if you were to be found guilty or admit to any of these, your probation could be revoked and you could be sentenced then on the underlying offense, and you're on probation to this court for operating while intoxicated, third offense, which is punishable by a maximum of 5 years in prison. Ms. Good, do you understand the rights that you have and the maximum penalty that you could face?
Yes.
And Mr. Villanueva, do you know how she wishes to plead?
She wishes to plead at this time not guilty, Your Honor.
Okay, well, enter a plea of not guilty and set the matter for a hearing. Is she requesting assigned counsel?
She does qualify for the office of assigned counsel, Your Honor, and Elizabeth Elliott will be assigned to her.
Okay, so let's then schedule this for the probation violation hearing on August 26th at 10 a.m. Okay, anything further from the defense?
I guess if you allow the defense to make an argument regarding bond, Your Honor.
Yes, go ahead.
All right, the defendant is a resident of Sheboygan County. She reports living on Riggsville Road. She's a mother to 2 children, 16 and 6 months, Your Honor. So that's all the defense has.
Thank you. Ms. Goodrich, people's position.
Your Honor, she is on probation for an OWI third. She has stopped engaging in treatment. She didn't appear for the last court hearing. I would ask that bond be revoked till August 26th.
Yeah, we had Ms. Good on pretty intensive probation in the recovery court program, and regrettably, she seems to have checked herself out from that program and failed to appear for court 3 times in the last month. 2 of them aren't even mentioned here because we dealt with them as sanctions within the program, trying to address therapeutic responses with her. And then she hasn't been reporting, hasn't been going to counseling, hasn't been testing, and didn't show up to court. So I don't really have much confidence that she would show up as directed. So I'm going to order her to be held without release pending further order of the court. But we'll set it then for the August 26th at 10 a.m. All right, we'll be adjourned. Sentencing, but then there was a show cause for an allegation of violation of bond conditions. So we adjourned the sentencing so that we could deal with that. So Mr. Penante, do you know how your client wishes to proceed on that alleged violation?
Yes, Your Honor. If I may remain seated.
Yes, that's fine.
Thank you. Mr. Appleford will be admitting the violation.
Okay, Mr. Appleford, if you please stand and raise your right hand as best you can for me. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, you can be seated, Mr. Appleford. Mr. Appleford, has anybody promised you anything in exchange for your admission to violating bond pay?
No, Your Honor.
Has anybody threatened you to make you do so?
No, Your Honor.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the allegation of contempt of court, guilty or not guilty?
Guilty.
So, Mr. Appleford, as a condition of your bond, were you not to have any contact with the complaining witness in this matter?
Yes, Your Honor.
And did you have some contact with her?
Yes, Your Honor.
And you were also not to use or possess any alcohol at all?
Yes, Your Honor.
And did you consume some alcohol while you were on bond?
Yes, Your Honor.
All right, Mr. Penante, you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
All right, well, Mr. Appleford, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis, in fact, in law to believe that you have violated your bond. So I do find you in contempt. And so then we can move into the contempt sentencing and also the underlying sentencing then. So Mr. Penante, have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Looks like we would need to make one correction to the jail credit. I think it was 2 weeks ago that I remanded him, so that'd be another 14 days of credit. Does that sound right to you, Mr. Penante?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Okay, so Mr. Penante, do you have any additional additions, modifications, or corrections to the pre-sentence report?
I do, Your Honor.
Okay.
I have had an opportunity to review further the statutory maximum issue in this case.
Yes.
And I would put an objection and note that I think the statutory maximum should be 20 months on the PSI. The basis for that is People versus Loveday, 390 Mish 711.
You mean 30 months, right?
People versus Loveday, 390 Mish 711, 1973.
No, you mean 30 months instead of 20 months, right?
Oh, yes, I apologize, yes.
Um, the attempt statute is the 750.92, right?
Correct, and People versus Loveday specifically analyzes section 3, the semicolon in section 3, which is at the end of the sentence, last sentence, a semicolon. But in no case shall the imprisonment exceed half of the greatest punishment which might have been inflicted if the offense so attempted had been committed. In full disclosure, in many places that I practice, that's just done as a matter of course, and I haven't necessarily figured out why that is. I have had an opportunity to review that a bit further. And I found this particular case, People versus Loveday, where the argument noted was that that limitation in the semicolon, subsection 3, applies to 1, 2, and 3, to everything preceding it. And the argument was that the defendant claimed that that limitation found in that paragraph applies to the entire statute, and the Supreme Court agreed and found that the 1/2 is the maximum sentence when it's an attempt. And specifically, they referenced a much older case, People versus O'Neill versus the People. That's how old it is. The V's are, they used to do it the old way. That's from 1867.
Can you give me the Loveday site again?
Yes, Your Honor. Loveday, Loveday.
Just the site.
Yes, 390 Mish 711, 1973.
Ms. Goodrich, do you have a position on it?
Your Honor, I was not familiar with this case prior to today.
All right, well, let's, just a second to read this. It's pretty short case. Yeah, in People Be Loved Day, it seems that that was not the prosecution was not contesting the defendant's interpretation of that statute, so that really wasn't the issue. The issue was the prosecutor was saying that it was an attempt to procure fit under the principal offense of the gross indecency, and it wasn't an attempted gross indecency. So I think when a point of law is assumed to be true, but it isn't a contested point, I think that's not, that would be dicta at most. And I think it's flatly contradicted by the structure of the statute, which has, different situations. One, if an offense is punishable with death, then it's a 10-year felony. 2, if it's punishable by life or 5 years or more, then it's a 5-year felony. And if it's less than 5 years, then it's a misdemeanor, punishable by not more than 2 years, but in no case shall it exceed 1/2. So I think that is contained in paragraph 3. It's not contained in paragraph 2. So I think I'm required to follow the binding language of the statute, not the non-binding dicta from a case that I think improperly interpreted that statute. So I'll leave it at 5 years. All right, any other additions, corrections?
I would also add, Your Honor, that they adopt the position in O'Neill versus People from 1867.
I heard that. I made my ruling. Okay,
Understood.
any other additions or corrections?
No additions or corrections.
Okay. The advisory guidelines were scored at 0 to 17 months. Any scoring challenges?
None from the defense.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, Mr. Penante, any allocution you wish to make on behalf of your client?
Yes, Your Honor. Your Honor, Mr. Appleford, I'll draw the court's attention to part of the PSI, which notes his familial upbringing. And I'm not a psychiatrist, a specialist of that nature. I don't purport myself to be, just that I work in the legal profession and I sometimes deal with psychiatrists and see people, and I ask myself for the patterns of their behavior and how someone comes to the point where they are in their life, where they're standing before a court, like Mr. Appleford is doing so here. And at least from the pre-sentence investigation report, what I can see is that Mr. Appleford had a bad familial upbringing, one where his father abused his family, where he was one that he received that punishment himself, physical punishment. And ultimately, Mr. Appleford would note that partially he blamed his mother for not protecting him or his family. The PSI also notes that he eventually moved to live with a maternal aunt, Mary Cias. The reason I draw the court's attention to that, it is often, as the court's aware, the case that those who suffer abuse in themselves later in life end up being abusers. That is, I would report why Mr. Appleford has come before the court on the domestic violence verdict. That's not an excuse Ultimately, there is no excuse because Mr. Appleford makes his decisions and his choices himself. He understands that. He's taking responsibility for that. And he's here today before the court because of that. Additionally, I would point out that Mr. Appleford is a veteran of our armed forces, the National Guard, that he was honorably discharged from that, and that his life greatly changed many, many years ago when he was far younger, when he was convicted of criminal sexual conduct. And that is the main reason for his high PRVs is that prior case and cases that happened afterwards within that gap. He successfully completed his parole and he was discharged from that. It wasn't easy, but he successfully did it. What that should tell the court is that he has the capability and means to be successful on probation. I understand the recommendation. There's also the safety of the victim to keep in mind, which if Mr. Appleford were put on probation versus with a term of jail, the court can then monitor his behavior and ensure that the parties and specifically the victim is kept safe. Additionally, the court is aware of the parties' contentious divorce. It is what it is. These things generally don't happen in a vacuum. Couples argue, and in Mr. Appleford's case, that argument came to violence, and he understands that. He bears the burden for his own decisions, Your Honor, and he asks that the court sentence him to a term of jail with probation. Thank you.
Thank you, Mr. Appleford. Is there anything you want to tell me today or no? You don't have to make a statement.
No,
but you're
Your
allowed
Honor,
to.
just that I'm embarrassed to be almost 59 years old, and once again, Your Honor, I'm standing in front of you. I apologize, but I accept the punishment as it is.
All right, thank you, sir. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant is 58 years old. He has 5 felonies and 7 misdemeanors. What is significant is when reviewing his criminal history, it involves sexual assault, animal cruelty, assault, domestic assault, and larceny in a building. So it's largely victim-based. There have been more than one bond violation of contacting the victim in this case. He was given a second chance by the court, but then continued contact thereafter, which led to his current status and incarceration. And I think also voids the sentencing agreement that was outlined at the time of plea taking. At this time, I would ask that the court order 12 months jail. If the court does order any probation, the victim does wish to continue the no contact order. Thank you.
Thank you, Mr. Appleford. If you please stand for the court sentence. Mr. Appleford stands convicted of attempted domestic violence third. And there was a sentence agreement for sentencing in the low end of the guidelines, but his post plea violations and contempt nullify that. And, you know, I understand with some of the contact violations that you were not the only person participating in that contact. It wasn't always completely unwanted contact. I understand that, which is why then the first time your bond wasn't revoked. But then knowing that you continued on that path, that was a really poor decision. But also then I note that, you know, you've got repeat domestic violence on the same victim. You know, contentious divorce certainly is no reason for that. Your first assault conviction was in 1991. Then you were convicted of a CSC in 1993 and given about 20 years in prison. You were paroled and discharged in 2013. And then in 2016, you got a domestic assault, 2019, a domestic assault, 2020, an animal cruelty, 2024, an impaired. And while you're on probation for the impaired, you get this case. While you're on bond for the impaired and you get this case. And I got to tell you too, if you were convicted as charged with the habitual fourth, that would be probably a prison sentence. And don't want to get into details, but you've now got financial reasons why you don't want to go to prison, because they will take that. If people go to prison that have means, the Attorney General will seize it to pay for the imprisonment. So apparently being sentenced by judges over the years, placed on probation or parole or locked up has not been enough motivation to get you to stop appearing in front of judges. So I'm trying to give you maybe another motivation that if you end up in prison again, you can kiss those means goodbye. So maybe that will help give you one more reason to check yourself before you cross those lines. But you do have a really significant criminal history and a fairly significant assaultive history, and here to the same victim over a period of time as well. The advisory guidelines are 0 to 17 months. I think given what I've outlined, there are reasonable grounds for incarceration. So I am going to order you to pay a crime victims assessment of $130, court costs of $350, state cost of $68, and I'll order you serve 12 months in the Sheboygan County Jail and give you credit for 21 days previously served. We're not going to impose any probationary sentence. On the contempt, it'll be 93 days jail, credit for 14 served. Those will run concurrent. And you can file an application for leave to appeal if you wish to the Court of Appeals, if you want a lawyer, and if you qualified, which I'm not sure you would now, but if you qualified, we'd appoint one for you, but you'd have to make that request within 6 months. We're going to hand that appeal paperwork to you and ask you to initial one copy for us. The other one's for you to fill out if you wish to take an appeal. Well, good luck to you, Mr. Apple.
Your Honor, would I be mailed a copy of the judgment of sentence, or
Yes, sir.
should I request that?
Yeah, we'll send one to counsel of records.
Thank you.
Go off the record to be in recess till 10.
Thank you, Your Honor.
All right, we're back on the record in the 53rd Circuit Court, and up next we've got People versus Walter West, file 25-7045FH. Counsel, you want to state your appearances for the record, please?
Anthony Julian on behalf of People.
Liz Elliott on behalf of Walter West, who joins us via Zoom.
Okay, and we're scheduled for a docket call today. Do you know how we're proceeding, counsel?
Your Honor, we have a plea agreement. The prosecution has agreed to allow Mr. West to plead guilty to an amended count 2 of attempt embezzlement of an agent or trustee 1,000 or more, but less than 20,000. And in return, the prosecution would dismiss count 1, the original count 2, count 3, and the habitual offender enhancement. And restitution is to be determined at a restitution hearing.
Okay, do you have a written plea agreement?
I do, Your Honor.
And you agree to the filing of the amended information?
I do.
All right, I received that. That's accepted for filing. Mr. West, would you please raise your right hand for me, sir?
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Are you Walter William West III?
Yes, sir.
Mr. West, a guilty plea hearing is an important event. It includes the waiver of constitutional and other rights that you have. So I want you to listen carefully. If you have any questions, ask them. If you need time to talk to your attorney, you just let me know. I have to advise you the maximum penalty for the attempted embezzlement over $1,000 is a felony, punishable by not more than 5 years in prison or not more than 1 year in jail. Oh, with probation, or is that like I don't understand what that statutory maximum, what that means. It's a felony punishable by a maximum of 5 years in prison. All right, do you understand that maximum penalty?
Yes, sir.
Yeah, I don't either. Okay, this says not more than 5 years in prison or not more than 1 year in jail. I'm not sure what that means.
In looking at the attempt statute under 750-92, it says not more than 1 year in jail or not more than 5 years in prison. So I don't know what that means either.
I guess I'm a little confused.
Or in the county jail, if not more. Okay, yeah. So it's just meaning that we don't have to send. Okay, I'm looking at that statute. All right, so Mr. West, what that just means is I don't have to send you to prison. If I don't send you to prison, the maximum is 1 year in the county jail. If I send you to prison, the maximum is 5 years. You understand that?
Yes, sir.
All right, are you on probation or parole?
Yes, sir. I was on probation.
At the time of this offense, you were on probation?
So like the events happened, I think before. It's just a little confusing. Before I was on probation, I've contacted them. They just said wait until the outcome. So.
Okay, so your probation agent knows about this offense?
Yes.
Okay, so I just want to make sure you understand that that could negatively affect your probation status, and it sounds like you do know that.
Yes.
Were you on bond for any other cases at the time of this offense?
No.
If you enter a plea, you won't have a trial of any kind, and you'll be giving up the rights that you would have had at a trial. Do you understand that?
Yes, sir.
I want to remind you of some of those rights. You would have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order them to show up. You'd have the right to testify in your own defense at trial or to remain silent and not have your silence used against you in any way. Do you understand those rights?
Yes, Your Honor.
Do you wish to give up those rights and enter a plea under this agreement today?
Yes, Your Honor.
If I accept your plea, you give up any claim that it was caused by any promises or any threats that aren't placed on the record today. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you lose the right to appeal. If you wanted to appeal, you'd have to seek permission by filing an application. The types of issues you could raise on an appeal by application are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, Your Honor.
All right, the plea agreement provides in exchange for your plea to the attempted embezzlement over 1,000, the original charges, remaining charges, and the habitual will be dismissed. Do you understand the terms of that agreement?
Yes, sir.
Has anybody promised you anything other than that?
No, Your Honor.
Has anybody threatened you to make you enter the plea?
No, Your Honor.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge of attempted embezzlement over $1,000 but less than $20,000?
Guilty, Your Honor.
Ms. Elliott, would you assist with the factual basis, please?
Yes. Your name is Walter William West III.
Yes, ma'am.
And were you in Beaugrand Township, which is in Sheboygan County, on May 21st of 2024?
Yes, ma'am.
Okay. And Mr. West, were you an employee of Roberts Landing Campground?
Yes, ma'am.
And that's owned by the Legio family?
Yeah.
I'm sorry, I missed that.
Yes, yes, ma'am.
Okay. And in the course of your employment at the campground, did you accept cash payment for customers at the campground?
Yes, ma'am.
And is it true that you kept some of that cash that was turned over to you and the amount is more than $1,000 but less than $20,000?
Yes, ma'am.
Your Honor, I believe that establishes a factual basis for the plea.
Okay, do you concur, Mr. Juliet?
Yes.
Ms. Elliott, are you aware of any other promises, threats, or inducements?
No.
Mr. Juliet?
I'm not.
Ms. Elliott, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, Your Honor.
Mr. Juliet?
Yes.
All right, Mr. West, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. Do council anticipate a contested restitution hearing in this matter?
At this point, I believe we do.
Okay. All right, not more than an hour in length of time, you think?
That should be enough, yes.
Okay. What we'll do then is we're going to schedule this for sentencing on October 7th at 9 a.m. And that way I'll reserve the 9 o'clock hour for that sentencing in case there's a restitution hearing. And Mr. West, you'll have to cooperate with a pre-sentence investigation and report. So you'll need to contact the probation department today, tell them you entered a plea so that you can schedule an interview. You have to cooperate with that process. Mr. Juliet, any objection to continuation of bond?
No objection.
Bond will be continued and the sentencing will be October 7th, 9 a.m. It'll be in person here in the courtroom for you, Mr. West, okay? Do you have any questions for me, sir?
No, sir.
Okay, we'll see you then.
All right.
Got the Emmett jail, so let's do Ms. Somerville. Hey, are you Jocelyn Somerville?
Yes.
All right, this is People v. Jocelyn Somerville, file 25-7054FH. Counsel, you want to state your appearances, please? State your appearance, please.
Melissa Goodrich, Wayne County Prosecutor.
No, not Gail here in person for Miss Somerville, who appears remotely from the Emmett County Jail.
Okay, and is her presence in the Sheboygan County Jail the explanation for her failing to appear at the arraignment?
In the Emmett County Jail, yes, Your Honor.
All right, and you agree with that, Ms. Goodrich?
Yes.
All right, so we'll dismiss the show cause for her non-appearance, and for purposes of arraignment, has she received a copy of the charging document?
She has not, Your Honor, no.
Okay, so Ms. Somerville, I need to advise you the charges against you. It's alleged that on or about May 13th of 2025 in the county of Sheboygan in the township of Walker, you did knowingly or intentionally possess the controlled substance methamphetamine contrary to Michigan law. That's a felony punishable by a maximum of 10 years in prison and or a $15,000 fine. However, the prosecuting attorney has filed a habitual offender notification that alleges that or takes notice that you were twice convicted of a felony or an attempt to commit a felony in that on or about October 19th of 2021, you were convicted of harboring felons in the Emmett Circuit Court, and on or about the same date, you were convicted of resisting obstructing a police officer in the Emmett Circuit Court. That would mean that in the court's discretion, the maximum punishment could be doubled, meaning that would be a felony punishable by a maximum of 20 years in prison and or a $15,000 fine. Do you understand that maximum penalty?
Yes.
And Mr. Nightingale, do you know how she wishes to plead?
Not guilty.
Well, enter a plea of not guilty. Is a forensic center referral requested?
No, Your Honor.
Estimated length of trial?
I would say 2 days.
Appropriate for docket call October 7th?
Yes, Your Honor.
We'll set it for October 7 at 10 a.m. Do we anticipate that she'll still be lodged in Emmett?
I'm not sure at this time. I hope that she's out, but I will reach out to her and advise the court if she's still in.
Okay. So I'll allow Zoom appearances for her if she's out and we're gonna enter a plea or something. Maybe you want to have her here. But
Sure. Sounds good. Thank you, Judge.
all right, Ms. Somerville, we'll see you October 7th. Okay.
Okay, thank you.
All right. Good day. All right, now it'll bring us to People v. Kayleen Zarzini. Kayleen Good. This file 23-6704FH and defendants present with counsel. We're here for a probation violation hearing. Ms. Elliott, do you know how Ms. Good wishes to proceed?
Yes, Your Honor. Ms. Good intends to enter a guilty plea.
Ms. Good, would you please stand and as best you can raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can be seated. All right. All right, so all the paperwork does still have to say Zarzini, which was the file that she came in on, but I'm gonna refer her as Miss Good. She had a divorce while since entered on probation, so the paperwork will still have to say Zarzini because of some tracking numbers we have to have with the state, but I'll refer to you as Miss Good.
Thank you.
All right, so Ms. Good, do you understand you have the right to have a hearing on these allegations where they would need to be proven by a preponderance of evidence?
Yes.
You understand you have the right to the assistance of your lawyer at that hearing?
Yes.
Has anybody promised you anything in exchange for pleading guilty to violating probation?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to do so?
Yes.
You are on probation to this court for operating while intoxicated, third offense. That has a maximum penalty of 5 years in prison. Do you understand that I could revoke your probation and sentence you on that underlying offense to that maximum?
Yes.
Knowing all these things, how do you wish to plead to the allegation that you violated probation?
Guilty.
So are you on probation to this court for OWI third?
Yes.
And you were ordered to complete the recovery court program?
Yes.
And on or about August 7th, in violation of that program and your probation, did you fail to submit a sample for drug testing?
Yes.
On or about August 7th, in violation of your probation in that program, did you fail to attend a counseling appointment?
Yes.
On or about the next day, August 8th, again in violation of your probation in the program, did you fail to report to your probation agent or case manager?
Yes.
On or about August 12th, did you again fail to attend a counseling appointment?
Yes.
And on or about August 12th, did you again fail to report to your probation agent or case manager?
Yes.
On or about August 13th, did you fail to appear for a recovery court hearing?
Yes.
And then did you thereby fail to, or did you fail to abide by the terms and conditions of recovery court program by failing to complete required community service hours for the first full week of August?
Yes.
And also thereby failing to successfully complete the recovery court program?
Yes.
Ms. Elliott, are you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
Ms. Elliott, are you aware of any promises, threats, or inducements at all?
I'm not.
Ms. Goodrich?
No, Your Honor.
All right, Ms. Good, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you have violated the terms and conditions of your probation. So I do accept that plea. These are technical violations. They are more than 4. So we're going to schedule this for a probation violation sentencing hearing, and I'll have the Department of Corrections prepare a probation violation report. And Agent Fagan, could we have that done by the September 30 date?
Yes.
We'll schedule this then for September 30 at 11:10 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay, we'll see you then, Kayla.
Thanks.
All right, and then this is Mr. Page. Okay, next we've got Peter Joshua Page. 25-7042. And we are here for a docket call. Ms. Elliott, do you know how we're proceeding today, what the status is?
Yes, Your Honor. We have a plea agreement whereby Mr. Page is agreeing to plead guilty to count 1, OWI third, and habitual offender second offense. In return, the prosecution is going to dismiss count 4 and the habitual fourth enhancement. There's a sentencing agreement that any incarceration ordered shall be within the Michigan sentencing guidelines. There's OWI reimbursement of $200, and Mr. Page does wish to avail himself to that agreement.
Okay, and do you have a advice of rights form you've signed with them then? Can we
I
get
do
that for you?
not.
Yeah. Yeah, on these, especially when there's a sentence agreement, but even on all of them, the recent court rule change makes it so that I should have those as well.
Your Honor, we'll be bringing up the amended.
Okay.
at a later time.
Okay, you consent to the later filing of the amended information with the habitual second?
Yes, Your Honor.
Okay, I'll give you a minute to go over that. Actually, could counsel approach? Refresh my recollection of what had happened in the previous case, and then talk with counsel and chambers about that. And based upon my review of that history, I advised them, Mr. Page, that I would not be accepting any plea bargain that included a sentence cap or sentence bargain in this case. So we'll not proceed with the plea taking today, and I'll schedule this for further docket call on
October 7th.
September 9th at 10:20. Anything further from the people?
No, Your Honor, thank you.
From the defense?
No, Your Honor, thank you.
Okay, we'll see you then, Mr. Page. See an iPhone. See, that might be Mr. Peterson. No. Are you Mr. Peterson?
Yes.
Okay, this is People v. Lewis Peterson, file 25-7002FH. Counsel, you want to state your appearances?
Melissa Goodrich, Blaine County Prosecutor.
Noah Nigel here for Mr. Peterson, who appears remotely via Zoom.
All right, and I was advised, I think last time, that he was applying to a treatment court in Chippewa County. What's the status of that?
Yes, Your Honor, that is still correct. Mr. Peterson, I think, is going to meet with the recovery court coordinator up there on Friday this week. It does sound like they're still very interested to have him, and I think that he is as well.
Any objection, Ms. Goodrich, to continuation of this hearing then?
No objection.
Any objection to Zoom appearances?
No objection.
All right, so Mr. Peterson, what we'll do is we're going to continue this then to September 30 at 10:20 a.m. We'll set that for a docket call, also a status conference on the pending contempt. We've just sort of been tracking since the scram tether. I haven't had any reports of violations. You still have that scram tether on, Mr. Peterson?
Yes, sir.
Okay. All right, and because we haven't had any violations on that, I'll still let you zoom in for that. If, and so Mr. Nightingale, if he's accepted into the Chippewa program, Please contact the assignment clerk and see if we can get him in sooner, even on a special date and time, just to have everybody zoom in for 10 minutes and get it rolling so we can start that program as soon as we can.
Of course, thank you, Judge.
Okay, anything further from the people?
No, Your Honor, thank
From
you.
the defense?
No, Your Honor, thank you.
Okay, Mr. Peterson, you have a good day.
Thank you, Your Honor.
All right, let's go off the record. We still need a little bit more time to get a mitigation memo to the people.
That's correct.
And Ms. Goodrich, any objection to continuance?
No objection.
We'll continue the docket call on both matters, as well as the status conference on the pending violations to September 30 at 11:20 a.m.
Thank you.
All right, so then that brings us to Ms. Escobar. People v. Sinessa Escobar, file 25-7046FH. Ms. Escobar is here with her lawyer, Mr. Nightingale. Ms. Goodrich is here for the people. And Mr. Nightingale, what's our status here?
Thank you, Your Honor. So Ms. Escobar is here in person out of custody. Very thankful to have her here. I think she drove all the way up from downstate. We're going to ask for another docket call. I think that we're probably going to resolve this, but she's got some health issues she needs to take care of before we're able to do that.
Okay. Any objection, Ms. Goodrich?
No objection.
And I don't want you to state her address since we're live streaming, but do we have a good address for her with the court?
I think that the court does. Same one. Okay.
All right. And what county is that in? Wayne County. All right. I will continue the docket call to September 30 at 11 a.m. Do you, are you requesting Zoom appearance for that date? Ms. Goodrich, do you have any objection to that?
Your Honor, I believe in a previous case, we did have problems with her attending by Zoom. If I recall, I would object.
All right, well, Ms. Escobar, I'm going to allow you to appear by Zoom for that hearing on September 30th. But that, I don't have a specific recollection of that, but that rings true to me that I've got a vague recollection that we did have some issues with you before, which probably explains why I made you come here in person today, but you did. So I'm going to reset it where you can zoom in, okay? But here's the deal. If you miss court, there'll be a warrant and you'll just sit in jail until we sort it out, whether it's a matter of days, weeks, or months. Okay?
No, thank you.
All right, so we'll see you September 30th at 11 a.m.
Thank you.
Thank you, Judge.
All right, that brings us to People v. David Shamas, file 2425-7047FH. Here for, looks like a status conference on a pending contempt. And also a docket call on the underlying case. What's our status here, Mr. McKeon?
Thank you, Your Honor. So Mr. Shamas has resolved his case that was down in district court. He is sitting on a sentence now there for an assault in the jail. We are going to request another docket call on this matter. I think we're still waiting on some updated restitution information.
No objection.
Okay. 2 weeks sufficient time, September 9th?
If we could not put it on the 9th, just because I have that training that day.
Oh, that's true. You've got a couple things on there that you'll need to get a step to us probably.
Right.
We've got, all right. You've already got a pretty busy day for us on the 30th. I can add a couple more to that, but then we're going to start hitting
the wall. Yeah.
Hitting the wall here.
If the court needs to go to October, I think that's okay. But
what was his sentence in district court?
He received the 93 days, the maximum that Judge Aaron could have given him.
Oh, So, and I don't know what his credit was, but if we put it out to October 7th, that doesn't prejudice him.
I don't believe so, no.
All right, let's put it on October 7th at 10:10 a.m. And continue status conference on the pending contempt. So October 7th, 10:10 a.m. So we'll next see you, Mr. Sims.
Thank you, Judge.
Thank you.
Yeah. File 25-6977FH. Counsel, you want to state your appearance, please?
Melissa Goodrich, Blaine County Prosecutor.
No, now I get from Ms. Carney, who appears in person in custody with my right.
All right, and we're here for our initially scheduled probation violation hearing after she was arraigned within the last couple of weeks. Do you know how she wishes to proceed today?
Yes, Your Honor. So it's my understanding, I don't represent her on her district court matter. Mr. Villanueva has that, but it's my understanding they intend to enter a plea at her next hearing, which is the 28th. I wish that these could have been a little bit backwards. We could have resolved this today, but if for whatever reason, judge doesn't accept that plea downstairs, or she decides to change her mind, we would just like to put this out for a few more weeks to see how that works out.
Any objection, Mr.
No objection.
All right, and
We will not
maybe-
plan on having any witnesses there at that next hearing though, unless
Okay.
notified. Yep.
Okay, well, I'll set it then for a status conference on it. You said the 9th is not a good date for you, so we can put it to the 30th.
I guess, is there any way that we could maybe do her at like 4 p.m. on the 9th? And
Yeah, I can put her in the afternoon.
I don't want to keep her longer than we need to. Or... All right.
I can do. Okay, so we'll continue this for a status conference on the probation violation for September 9 at 4 p.m. and indicate that we'll do that hearing by video.
Thank you.
We'll see you then. And then is this Mr. Jewell? All right, and this is scheduled for arraignment, and I have a plea agreement for entry into a recovery program. Is that how we're proceeding, Counsel?
Yes, Your Honor.
Yes.
So for purposes of arraignment, it's a forensic center referral requested.
No, Your Honor.
And do you and your client waive the reading?
We do.
Mr. Jewell, would you please stand and as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You put your hand on, you sit down. Okay, Mr. Jewell, guilty plea hearing is an important event. Includes the waiver of constitutional rights that you have and other rights that you have. So if you have any questions, ask me. We're happy to answer them.
Okay.
If you need more time to talk to Mr. Nightingale, you just say so anytime. We're happy to give you that time. Do you understand that?
Thank you.
Now, I have to advise you the maximum penalty that you could face for these charges. Count 1 and count 2 both allege possession of methamphetamine. The prosecutors also filed a habitual 4th notice based on your prior felony record, which means that both those count 1 and count 2 are punishable by a maximum of life in prison and or a $15,000 fine. Count 3 is a charge of fleeing and eluding in the 4th degree. With the habitual 4th notice, that would be a felony punishable by a maximum of 15 years in prison and or a $2,000 fine. And the Secretary of State would suspend your driver's license for not more than 5 years. Count 4 is a charge that you possessed a controlled substance, 25D NBOME. That's a felony with the habitual offender notice, punishable by a maximum of 15 years in prison and or a $2,000 fine. Count 5 is a charge of operating while your driver's license was suspended or revoked as a second offense. That's a misdemeanor punishable by maximum of a year in jail and or $1,000. Do you understand the maximum penalty for those charges?
Yes, Your Honor.
Are you on probation or parole anymore?
No, Your Honor.
Were you on bond for any other case at the time of this matter?
No, Your Honor.
Did you read and understand the rights listed on the advice of rights form?
Yes, Your
And
Honor.
you signed that?
Yes.
Do you have any questions for me or for your lawyer about any of those rights?
No, Your Honor.
Do you understand if you enter a guilty plea, you give up all those rights?
Yes, Your Honor.
And is that what you wish to do?
Yes, Your Honor.
If I accept that plea, you give up any claim that it was caused by any threats or by any promises beyond the terms of the plea agreement. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you have to seek permission by filing an application. The types of issues you could raise on an appeal after you plead guilty are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, Your Honor.
The plea agreement provides in exchange for your plea to all of those charges, there's a sentence agreement for the Sheboygan County Recovery Court program. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Nightingale's got a full, fair, and accurate terms of the statement of the agreement?
It is, Your Honor. Thank you.
Yes.
So, Mr. Jewell, that sentence agreement is not binding on me, meaning at the time of your sentencing, when I have the benefit of a full pre-sentence report, I don't have to follow that. The team has already talked about your application, and we thought that you were a good candidate for the program, but the final decision would be mine at the sentencing. If I don't follow that agreement, you'd be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, Your Honor.
There is a very important exception of that rule. If you say abscond on a bond, don't show up for court, or go commit more crimes, or violate court orders, you engage in misconduct between now and the sentencing date, then I don't have to follow the agreement, but by your misconduct, you would lose the right to withdraw your plea. Do you understand that?
Yes, Your Honor.
So if you are sincere in your mind about making very significant changes in your life, making an honest effort at sobriety, this is a good plan for you.
Yes, Your Honor, it is.
If you have any hesitation about that, or you just want to get yourself out of jail today, this is a very bad plan.
No, I understand.
Because Mr. Nightingale can get you a better plea bargain than pleading as charged.
Yes.
And I want you to know going in, only about half of the people who enter the recovery court program graduate from it. We will do everything we can to work with you. We will not work harder than you do.
I understand that.
Other than the plea agreement, has anybody promised you anything to get you to enter this plea?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 1, possession of methamphetamine?
Guilty.
Count 2, possession of methamphetamine?
Guilty.
Count 3, fleeing and eluding 4th degree?
Guilty.
Count 4, possession of 25D NBOME?
Guilty.
Count 5, DWLS second?
Guilty.
And habitual offender 4th.
Guilty.
So, Mr. Jewell, on or about April 11th of 2025, were you in Sheboygan County?
Yes, Your Honor.
Were you driving a motor vehicle?
Yes, Your Honor.
And were you driving that on a public roadway?
Yes, Your Honor.
Was your license suspended or revoked?
Yes, Your Honor.
Did you know that it was?
Yes, Your Honor.
Did you have a previous conviction for such?
Yes, Your Honor.
Did you have contact with law enforcement?
Yes, Your Honor.
Did you know that it was a law enforcement vehicle?
Yes, Your Honor.
Did they give you some kind of signal by their lights or sirens or otherwise that they wanted you to stop the vehicle?
Yes, Your Honor.
Did you fail to immediately stop the vehicle?
Pulled into the driveway, Your Honor, so yes.
Was it your driveway?
No, Your Honor.
Okay, so you were trying to evade being stopped or captured by the police?
Yes, Your Honor.
And did they find you to be in possession of controlled substances?
Yes, Your Honor.
Was one of those substances this 25D NBOME?
Yes, Your Honor.
Did you know you were in possession of that?
I did not know that's what it was. Your
You
Honor.
knew you had controlled
I had
substances?
something, yes.
Okay. Do you know what that is?
No.
That's what it tested positive for?
Yes.
Do you have any reason to dispute that test result?
No, after I looked it up online, what it said, it pretty much was.
Okay.
Understandable.
Were you also in possession of methamphetamine?
Yes, Your Honor.
And did you know that you were in possession of that?
Yes, Your Honor.
There's 2 counts of possession of methamphetamine. Do you know why?
No, I did not.
Mr. Nightingale?
So they tested a few different items that they got mostly from Mr. Jewell's house. There was 1.9 grams in no container that true narc positive is methamphetamine. There was another cylinder glass meth pipe that true narc positive is methamphetamine.
Was there some, so I guess were you in possession of methamphetamine in the car?
Yes.
Okay. And then did the police later search your house?
Yes, sir.
And did they find methamphetamine at your house?
Just my tools, more or less. So yes.
And there was
I have,
methamphetamine residue that tested positive on those?
yes, Your Honor.
Okay, and those belonged to you?
Yes, Your Honor.
And you had used them for methamphetamine?
Yes, Your Honor.
All right, and the stop and your home are both in Sheboygan County?
Yes, sir.
Mr. Nightingale, you satisfied that?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes.
Mr. Nightingale, are you aware of any other promises, threats, or inducements?
No.
Ms. Goodrich?
No, Your Honor.
Mr. Nightingale, your judgment is the court fully complied with the requirements of MCR 6.302?
The court has.
Ms. Goodrich?
Yes.
All right, Mr. Jewell, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses.
Yes.
So I hereby accept your plea and schedule sentencing for October 7 at 10:20 a.m. And Mr. Jewell just hasn't posted bond on this matter, or what's the status of detention?
So Judge, we had him on a stipulation for furlough to treatment. There was some miscommunication and he actually turned himself back into jail because I could not get another stipulation signed for him. And so I think that our agreement today would be to release him to the recovery court conditions, have him meet with Nicole upon release from the jail.
He was originally incarcerated due to some bond violations, but he since has completed inpatient.
Okay, so you have no objection to amending to recovery court conditions?
No objection.
And Mr. Nightingale, do you consent to his participation in the review hearings without you being present?
I do.
Okay, so Mr. Jewell, what I'm going to do is amend your bond to a $5,000 personal bond with recovery court conditions. What that means is we're going to start you on the program right away.
Okay.
When you get released, it'll probably be yet today. If we get tied up in paperwork, it's possible it would be tomorrow, but we'll try to get it out today.
Right.
When you're released, come right around, come back in the building and see Nicole.
Okay.
And then you'll have to be in court tomorrow morning at 9:30 a.m. That's when the men come. And every week, in phase 1, you'll be seeing me every week. And we have a defense attorney on the team, but it's not Mr. Nightingale. So Mr. Nightingale won't be in court with you. It's just for us to touch base with our participants each week to see how they're doing. If there's any violations or how we're going to deal with that, you know. If there's anything happening between now and your sentencing at that review hearing where you don't feel comfortable without talking to Mr. Nightingale, you just let us know.
Okay.
And we'll pump the brakes on it and let you talk to him. Okay. You have any questions for me about that?
$5,000 bond.
So that's a personal bond. It just means that if you don't appear,
Okay.
there'd be judgment that it would issue against you for $5,000.
Okay.
Ouch, ouch. Ooch.
Anything further from people,
Yeah.
from the defense?
No, Your Honor, thank you. Don't forget to-
Case, but I did talk to counsel off the record. It's people be done, and he's still completing some treatment, and it sounds like the prosecutor wants to know how that goes in order to decide what the offer is on the new charge and on the probation violation. Is that correct, Ms. Goodrich?
Yes.
Okay, so Mr. Nightingale, defense would like an adjournment of the probation violation here.
Correct.
Okay, so we'll schedule it for a status conference on the probation violation hearing for October 7 at 10:40 a.m. Let Ms. Goodrich know if you need that to be a contested evidentiary hearing. I'll excuse Mr. Dunn's appearance here today. We called the case a little early, and you can advise him and the treatment facility that his presence is not needed.
Sounds good. Thank you, Judge.
Okay, thank you. We'll be in recess till 1 p.m.
Thank you, Your Honor.
Yeah. Cha-ching. Let me look up something here. Playlists. Sure. This. Gauthier. Yeah. $210 people watched that yesterday's live stream, or viewed yesterday's live stream. Wow. Some of these get good numbers and some of them don't get good numbers. But the fact is, some people were banned. The majority of the main aggressors are still banned, but some of the rest of them are not banned anymore. And I feel like this. It's to the point that I don't like to ban anybody. Everybody is welcome here as long as you behave themselves. But Trin told me a little trinket in email, which I'm not going to repeat what she said. But yeah. So some people are not banned and some people are banned still. And one's banned because of guilty by association. But the 73 subscribers, I am so welcome you guys. If you are not a subscriber to this channel, before we continue, I want to make this point clear. If you're not a subscriber to this channel and you like the content that's being put out on this channel, please consider subscribing to this channel and helping this channel grow. And make sure that you hit all notifications. When we go live, that you get the notification. I got the notification when I went live. And there's something else I want to talk about. What the hell was it? Oh, technically I am retired from doing computer stuff. So whatever video content that I have about computers and technology, that's going to be it. And it's something, I come and do something, but basically I'm just retired. I wanted to talk about something different on this channel. I mean, that's my right. And that's why I thought about doing courts and court cases. Because, I mean, I did computer stuff for 30 years. I've been a content creator since 2015. I think the new content is getting more views than any other content. And this thing with Elemental P, I won't talk about it because it's the whole thing is just ridiculous. In my opinion, I think you should stop this crap take your lumps, because you're the one that started all of this. Filing for bankruptcy does not get you out of the cases. It stays it for a little bit. And I would take Tug's advice. Go after Lisa Lee. What she did is a crime. Call the Levy County Sheriff's Office and file a report against her. She raised money in your behalf and you didn't get anything from it. That's against the law. What she did is against the law. No matter how you look at it, what she did is against the law. And you need to file a police report. Because if it happened to me, it happened to me. I got scammed. And something that Trin said in an email, they should give me my money back. Because we were scammed. But that's here nor there. I'm not a lawyer, so I can't, but I would take Tug's advice. File a police report against her and take this a little bit further. Because she collected money in your name and in that child's name and didn't give you a dime of it. That's fraud. This might be a short one. Where are we? Right there? No? This might be a short case.
We are providing public access both in the courtroom and also online. And we have a jury trial tomorrow in People versus Nicole Fisher, 24-6929FH. I'm told there's been a late-breaking resolution of the case, and I have a plea agreement in front of me with a second amended information and advice of rights. Is that how we want to proceed this morning, Council?
Yes.
Good, John, thank you.
Okay, and so Ms. Goodrich, I had a previous motion to amend the information. Are you proceeding on that motion or no?
No, Your Honor, I'd ask to withdraw that motion.
Okay, and the second amended information you've presented today, Mr. Gilbert, do you consent to the filing of that motion?
I do.
Or that information?
I do.
Ms. Fisher, would you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Put your hands up. Ms. Fisher, a guilty plea is an important hearing. It includes the waiver of constitutional rights that you have. So I want you to listen very carefully. At any time, if you've got questions, go ahead and ask me. I'm happy to answer them for you. If you need more time to talk to Mr. Gilbert, you just let us know. We're happy to give you that time. I have to advise you the maximum penalty that you could face for the charges you'd be pleading guilty to. Amended count 1 is assault, is felony assault. And that is a felony crime punishable by a maximum of 4 years and or $2,000 fine. Count 2, resisting or obstructing police, is a felony punishable by 2 years and or $2,000 fine with a consecutive sentence in the court's discretion for any violation arising out of the same transaction, which means that it could, in the court's discretion, be the 4 years plus 2 years for 6 years. And count 4, child abuse in the 4th degree, is a misdemeanor punishable by 1 year in jail or probation for up to 5 years. So that would be concurrent. So the total maximum exposure you would have for these charges would be the 4 years plus 2 years or 6 years. Do you understand that? Are you on probation or parole?
No.
Were you on bond for any other case at the time of this incident?
No, sir.
Did you read and understand the rights listed in the Bill of Rights?
Yes.
And you signed that today? Do you have any questions for me or for Mr. Gilbert about any of those rights? Do you understand if you plead guilty, you give up those rights and won't have a trial? Is that what you're choosing to do today?
Yes.
If I accept your plea, you give up any claim that it was caused by any threats or by any promises beyond the terms of the plea agreement. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal to a higher court, you'd have to seek permission to appeal. You would do so by filing an application. But the types of issues that you could raise on an appeal after you plead guilty are very limited, much more limited than if you were convicted after the trial. Do you understand that? The plea agreement provides in exchange for your plea to amended count 1, count 2, and count 4 as I outlined. The prosecutor will dismiss the original charge, the original count 1, the remaining counts, as well as the habitual offender notice. And there is a sentence agreement for a county jail cap, meaning you could be placed on probation. If you violate probation, could be different, but that the initial sentence would be no more than 1 year in the county jail. Do you understand the terms of that plea agreement?
Sure.
Mr. Gilbert, is that a full?
I want to say this, okay? If you're doing stuff to children, you need to get locked up for 30 or 40 years, no matter what it is. Even the two cases that I showed, the cases that I showed earlier in the stream, one guy got 30 years, 25 years, 25 to 30 years for doing something to a child, to a minor. You're sick people. I don't know if locking you up is going to be the answer to it. I guess locking you up would be the answer to it. But you also need a psychological evaluation. Yeah, I agree with Linda. And Linda, I understand what you're going through. Please don't, I understand what you're going through. And anytime that you want to talk to me, you can call me. If you want to talk, you're welcome to call me and we can talk. I enjoy our conversations. But yeah, you need to be locked up for life, especially when you're doing something to children. And there's a special, when you die, there's a special place in hell for you. I don't have children. I have two nephews and a niece. And God forbid if something bad happened to them like that. I don't think I'd be very peaceful about it. I don't think I'd be very peaceful about it. I'd be very patient with people that are like that.
Full, fair, and accurate statement of his terms.
It is, Your Honor. Thank you.
Ms. Gilbert?
Yes.
Ms. Fisher, that sentence agreement for the county cap is not binding on me, meaning I don't have a full pre-sentence report yet. Once I get that, if I decided that no, it would be my intention to send you to prison on this case, then you would be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, sir.
There is an important exception to that. If you engage in any misconduct between now and the sentencing date, say by absconding on bond or skipping court, committing a new crime, violating conditions of your bond, by your own misconduct, you would lose the right to withdraw the plea, even if I went above the sentence agreement. Do you understand that?
Yes, sir.
Other than the plea agreement, including that sentence bargain, has anybody promised you anything to get you to plead guilty today?
Yeah.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 1, felony assault?
Guilty.
How do you wish to plead to the charge in count 2, resisting or obstructing Trooper Sharp?
Guilty.
And how do you wish to plead to the charge in count 4, child abuse in the 14th?
Guilty.
Mr. Gilbert, would you assist with the factual basis,
I'd
please?
be happy to, Your Honor.
Ma'am, can you state your name for the record?
Nicole Lynn Fisher.
And Nicole, were you at your house on September 20th of this year?
Yes.
And that house is located in Sheboygan County?
Yes.
And at that house on that evening was your son?
Yes.
And you had been drinking?
Yes.
And a argument ensued between you and your son about him leaving the premises?
Yes.
And in the course of that argument, at one point in time, you grabbed a hold of him or put your hands on him?
Yes.
And he did not want to be handled in that form or fashion?
Yes.
And so in addition to that, at a later point in time in the evening, you grabbed a hold of his shirt?
Yes.
And also, that was something that he did not want to?
Yes.
And the police were called based off of this incident?
Yes.
And at some point in time, you had contact with Michigan State Police?
Yes.
And they had requested, they attempted to arrest you because of this incident? And you resisted them and pulled away and were fighting with them basically?
Yes.
And again, that all happened when you were down. I have no further questions, Your Honor. Thank you.
You're satisfied with the factual basis, Mr. Gilbert?
I am, Your Honor.
Ms. Goodrich?
Yes.
Mr. Gilbert, are you aware of any other promises, threats, or inducements?
I have not.
Ms. Goodrich?
No, Your Honor.
And Mr. Gilbert, in your judgment, has the court fully complied with the requirements of MCR 6.302?
The court has, thank you.
Ms. Goodrich?
Yes.
All right, Ms. Fisher, we've asked you a lot of questions. We've given you a lot of information. We have a bunch of jurors ready to show up tomorrow. I'm sure you and your lawyer are prepared for this trial. So we can go forward with that. It's totally your choice. So I just want to confirm with you that you want to waive your right to have that trial tomorrow, and you want me to accept this guilty plea today?
Yes.
All right. Are you entering that plea because you are guilty? All right. Well, Ms. Fisher, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you committed those offenses, or certainly the greater is to count one. So we'll accept your plea. I'll schedule sentencing for October 21 at 2:30 in the afternoon. Ms. Goodrich, do you have any request about bond?
Oh, Your Honor, I have no objection to bond continuing at this time.
Okay, we're going to continue the bond, Ms. Fisher. So before you leave today, I want you to stop by the probation department. Tell them that you entered a plea and what your sentencing date is. And they'll schedule an interview for you. You'll have to fill out a packet, I think, and then do the pre-sentence interview so that I have a full report on the sentencing. Do you have any questions, Bill? Anything further from the defense?
No, Your Honor, thank you.
From the people?
No, Your Honor.
Okay, we'll see you then.
Thank you.
All rise.
All right, kids, kitties, that's all for today. Tomorrow is going to be I guess tomorrow is just a hodgepodge of different cases with different judges, stuff that's been miscellaneous. I could have stuck them in the right playlists, but I didn't. I thought, well, maybe we'll just do miscellaneous stuff on Saturdays. If we get enough people in here on a Saturday, I'm going to put a poll. Either today or tomorrow, I'm going to set up a poll in the community post if you wanted to go back to doing trivia. But there has to be enough people in here to contribute to it. So, again, if you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to my channel. When you subscribe to my channel, you're helping my platform grow, you're helping my channel grow, you're helping my community grow, and you're helping my family grow. Because we're a family here. We look after each other. Just like Trin, Linda, Gail, and Musa Lady, who are moderators on this channel. They look after me. They do what they're supposed to do. But by subscribing, you're helping to grow this channel. And I hope in due time that you will subscribe to this channel. I like talking about courts and court cases. It beats everything else that I've ever been doing online. So for now, it's ta-ta, ciao, ciao. Hasta la vista. I will see you again tomorrow at 3 o'clock. I believe I scheduled that for 3 o'clock instead of 4 o'clock. I will see you guys tomorrow. You have a wonderful evening. And be good if you can. If you can't, at least try. And what's John saying? It's easier to be kind to one another than it is to be mean to each other. Something like that. So ciao, ciao. I will see you guys tomorrow. Have a good one, everybody.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost, gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, now I'm standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's over.